Hi, everyone. Welcome to Plan Giving Council of the Mid-South webinar. It is Wednesday, September 30th. Thank you all for joining. Today, we will talk about the life of a planned gift from A to Z. You will see that you have two ways to ask questions. There's a chat box and a Q&A. Either place is great for you to type your questions in, and we will answer them as we go. Today, we have several presenters, and I will let Joey Maruzzi, president of the Plan Giving Council of the Mid-South, to give an introduction.
Good morning, everyone. Thanks so much for joining us for the second part of our fall programming. As Sarah pointed out, the life of a planned gift. The board of the Plan Giving Council of the Mid-South, we work to bring you a variety of programs each year in partnership with the Community Foundation and the Jewish Foundation at no cost to our members. So please keep in mind, hope you'll consider joining us if you're not already a member. Traditionally, not during a pandemic, we do bring in experts outside of our board and include lunch, which really makes the $125 a year pretty minimal and more than a break even. But for today's program, The Life of a Planned Gift, you'll be hearing from several local experts. Mike Adams, a local attorney and CPA with Evans Petrie, will be on the call. Carlisle Dale from Wiseman Bray, also an attorney, will be on the call. Dan Merle, previously of University of Memphis and now consulting locally and nationally, will be on the call, and Kathy Wilson from Le Bonheur, who is a Plan Giving director and also an attorney, will be on. Sarah Vanderwald from the Jewish Foundation will be facilitating and, as she said, taking questions via chat. So do send those, anything you may have for the presenters. Again, thanks so much for joining us, and let you guys get started.
Okay, today's agenda, we're going to go through the types of planned gifts, acknowledging and stewarding planned gifts, meeting donors' wishes, and probate and non-probate gifts in Tennessee. And I'm going to hand it over to Carlisle.
Yeah, good morning, everyone. And thanks, Sarah and Joey, for that introduction. So just in talking about the different types of gifts, I'll start us off with bequest. And so I think probably everybody on today's call is familiar with what a bequest is. And so, you know, bequests are just simply planned gifts, which are included in a donor's estate, like a will or a trust estate plan. Bequests can take different types of forms, such as cash or particular assets, like specific accounts or items of personal property. And I'm going to discuss the probate process actually later in our presentation today, which will be the process by which a charitable organization is going to receive a bequest under a will estate plan. So but we're also going to talk about how an organization can work through the probate process with a personal representative, the timing of this process, as well as other aspects of the probate process. So I think I'll turn it to Kathy now, who's going to talk about gifts of appreciated securities.
So, hi, welcome everybody. Talk a little bit about appreciated securities. There are many benefits to making gifts, appreciated stock, bonds, mutual funds, especially for donors when they have owned that stock for at least a year. The donor's not going to pay they're also going to receive immediate deductions in realized value. A lot of owners have a lot of their net worth in stock. It must really make it easy for your ask your donors to let you know
I think we lost Kathy. You were breaking up. Kathy, are you still there?
I think we can move on to beneficiary designations.
Okay.
Hello, everyone. My name is Mike Adams, and we kind of lost Kathy there, I think, due to some technical difficulties. So we're going to move on to beneficiary designations, which oftentimes are one of the most common ways that people choose to leave assets, simply because it is very simple and they don't need to see an advisor, which is both an advantage and a disadvantage, frankly, because sometimes they make gifts without tax advice when it could have been more efficient. But there's generally three broad categories that people use beneficiary designations for. The first are retirement accounts. And many of you may be familiar with distributions from retirement accounts from the qualified charitable distribution, where people can make that during life directly from an IRA. However, what we're talking about here is where that account passes upon death. So that's simply a form or a designation they fill out with the plan custodian or the plan administrator, and that directs where it goes. It can be done in percentages, so it does not have to be 100% to anyone. Oftentimes people may say, I want 20% to go to a charity and I want 80% to go to my children. The benefit, of course, is that if any portion going to the charity is not going to be taxable income to the beneficiaries or the estate. Another broad category is annuities, which is similar to insurance. Annuities are kind of a hybrid. Part of the distribution from annuities are generally taxable to the recipient and part are not taxable. And so again, there's still a benefit of leaving this to charity, and that would be done in the same manner as we discussed with the retirement account. Simply a form they fill out with the annuity, the insurance company, saying where they want that account to go. And then lastly, insurance policies. No real tax advantage on insurance policy passing to charity because there's no income tax on insurance. And same thing, you would fill out a form with the insurance company. And as we'll talk more about this later on the advantages and disadvantages of the beneficiary designations, but speaking broadly, the advantage is simplicity in not having to pay fees to an accountant or an attorney for the client. The disadvantage is they don't get advice. And from the charity who is receiving it, they have advantages and disadvantages as well. We'll go into it more later, but the advantage is they can get it quicker and it's not subject to the claims of the deceased person's creditors. However, the disadvantage is it's sometimes hard for the charity to find out that they are the beneficiary because they're not passing through the estate, which Carlisle will talk about, and there may not be any one person that is quarterbacking those. So sometimes that is a challenge, and we'll talk more about that later. And with that, I think we'll turn it over to our next speaker on donor advised funds.
Thank you. Good morning. A little bit about donor advised funds. They are generally held by the community foundations, and we have people in the audience today that are with the various community foundations in Memphis. Generally, they are going to be at a community foundation, but there are organizations that can offer donor advised funds other than those. However, in most cases, there are three parties. You have the donor who's going to make the contribution and gets an immediate tax deduction. And one of the values of a donor advised fund is that it completely separates the moment of a tax deduction from the charitable giving. They get that immediate tax deduction, say December the 31st, and they give $100,000 of stock. They go ahead and get that deduction that day and reserve the right, the privilege of making gifts from that fund at a later time. They can name the advisors to that fund. So you could other than the donor himself or herself, they may name their children to be advisors. And it can take place over generations. Every community foundation is a little bit different, but it is not unusual to have children being able to name their advisors later on as well. And then the donor, the main purpose, I suppose, is to be able to recommend charitable beneficiaries and amounts. So the key word there is recommend. Ultimately, you have made a gift to the community foundation and relinquished control. However, the community foundation has it in their best interest to honor your wishes and make gifts where you intend. The second party to this is the public charity, the community foundation itself. And they hold and invest all these gifts from the donors. So you have the benefits of the combined combination of all the assets that they have, several hundred, it can be hundreds of millions of dollars. And they are going to follow the instructions from the donor regarding making those charitable gifts. And while those funds are there, you got tax-free growth on those fund assets. So you can sort of think of a donor advised fund as a charitable checking account that is growing. And you can, the only people you can write checks to are charitable organizations. So finally, there is the charitable beneficiary. And I think most of the organizations on this call have received gifts from public charities or community foundations. You can also, one benefit of a donor advised fund is that you can create an estate plan for your fund as well, and have perhaps charities will be the ultimate beneficiaries of that fund down the road. All right, pass that on. There are three in town: the Community Foundation of Greater Memphis, Jewish Foundation of Memphis, and the Christian Community Foundation. And I'll pass that on then to the next person.
All right, and so can you hear me now, Sarah? Does it sound okay?
Yes, much better.
Okay. So I apologize, everybody. I rebooted my computer. I'm not sure what happened. I was going to talk about real estate, which I'll cover a little bit later on also. But real estate can be a great gift. I was supposed to talk earlier about appreciated securities. You know, anytime your donor can make a gift of something that if they sold it, they would have a lot of tax consequences from capital gains tax, maybe a great gift for the donor, but also for organization. There are going to be some special considerations for gifts of real estate, which we're going to talk about later. But you want to be very careful for the organization that you vetted any real estate gifts that you take. And Sarah, if you'll move to the next slide. You know, another way to give real estate is you may have a donor that says, I want to give your organization my house, my vacation home, but I actually want to use it for the rest of my life. And so they can do that by giving the gift, the property to your organization, but retaining a life estate, which gives them the right to use that property rent-free. And that's also a great gift for an organization because that gift is then irrevocable. You know, they could leave the property to you in their will, but then change their mind. But once they transfer it that way, it is an irrevocable gift. And now we're going to turn over to personal property, which I think is Carlisle.
Thanks, Kathy. Yeah, so generally when I talk with clients about personal property, I'm referring to household items like their furniture or jewelry or electronics or vehicles and things like that. But I think in the gifting world, personal properties more likely or just as likely to be items such as collectibles like artwork, coin collections, and things of that nature. And gifts of personal property can either be during a person's lifetime or request under a decedent's will. And you run into a lot of the same issues with gifts of personal property that you do with gifts of real estate. So some special considerations should be taken into account. For example, you know, gift acceptance issues and policies. Is a gift of personal property, like a vehicle, something that an organization can handle or can they benefit from? You know, is the gift something that's has a readily ascertainable value? Can it be appraised? Does it have any value at all? Is there any benefit whatsoever from receiving a gift of personal property? So gifts of personal property can be a little bit tricky to deal with depending on the organization, but they can also provide a substantial benefit depending on the value and the type of gift. And so that's a little bit about personal property, and I think I'll turn it to Dan now to discuss charitable gift annuities.
Sorry about that. Charitable gift annuities are a life income gift. The donor makes a one-time gift to the organization. There is a simple contract. I think the last one I used was 4 or 5 pages, 2 of which actually had most of the information on it. And the gift is the life income is going to be backed by all of the assets of the organization. That means it is generally a larger organization that can handle these. Because in return, the organization is going to make fixed payments to one, usually the donor, or 2 annuitants, usually for life. And rates for a charitable gift annuity go up as their age does. So it's a fixed rate at the time of that you make the gift. The donor gets an income tax deduction for the present value, which is, I'm going to say, is roughly half of the gift. And regulations definitely vary by state. In the state of Tennessee, the funds, I believe, must be segregated from other assets of the organization. And in previous places that I have worked, we have tried not to touch that until the gift is no longer paying out to the donors. So it's a valuable gift, but it's not something a lot of organizations tend to use. Thanks.
Sorry about that. We're going to talk about trust for a few minutes, and there's different types of trust. Before we start talking about the different types of trust, I want to kind of explain what a trust is. It's an agreement between the grantor, or the person making the trust, and the trustee to hold assets for the benefit of a third party, the beneficiary. Trust can be both revocable, meaning you can change it, the grantor can change it, or irrevocable, meaning they can't. And you have trusts that are created during life, and you have trusts that are created at death, called testamentary trust. The diagram on this page is a diagram of a revocable trust, which becomes irrevocable or irrevocable at the grantor's death. And then it creates a charitable lead annuity trust. And so to kind of use, well, and the purpose here is to try to avoid estate taxes. So you'll see in the diagram that red dotted line coming across. At the grantor's death, we put a certain amount into the, we put really amount into the trust for the children. And in this case, it's an amount necessary to avoid estate tax goes into the charitable lead trust, which then pays out basically an amount each year to the charity for a period of years. And then if the assets grow inside that charitable lead trust more than is paid out to the charity, you'll see at the bottom there, the green arrow, the balance at the end of the trust comes back to the children. And to use some real numbers to let you kind of see the power of this, let's say a person had a $15 million estate, and the estate tax exemption now is roughly $11.5 million. If they did not use this charitable planning, they would have 15 minus the 11.5, meaning 3.5 million would be subject to tax. The tax rate's 40%, but next year it may be 50. So I can do the math in my head. I'm going to say 50% tax. So that would be roughly $1.75 million in tax. So there's $1.75 million that's gone to the government, and the children get that other $1.75 million. But with this technique here, 3.5 million would go to the charity, 0 in tax, and the children would still get the 11.5. So the children get a little bit less, but there's a lot more available to accomplish charitable purposes in the community. So that's a demonstration of that. So if we'll go to the next slide, we'll talk about charitable remainder trust. Charitable remainder trusts are kind of the opposite of the charitable lead trust. As we discussed, the charitable lead trust, the charity leads it. They get the income or the benefit first, and the remainder goes to the children or the other beneficiaries. With a charitable remainder trust, it's the reverse. The individual beneficiaries get the money first, and whatever is remaining at the end of the trust goes to charity. These are commonly used when someone has appreciated assets. So if you'll see under tax considerations, kind of the second bullet point there, the LTCG stands for long-term capital gain. So let's say I've got an asset that's worth $100,000, but I paid $10,000 for it a long time ago. If I sell that myself, there's a gain of $90,000 that I have to pay roughly 20% tax on, or $18,000, and then if I turn around and give that to the charity, that's $18,000 less that the charity would get. But instead, if I used a charitable remainder trust and contributed that $100,000 stock into a charitable remainder trust, the trust could then sell it tax-free and avoid that $18,000 of taxable gain. And then when the money gets paid out to the beneficiaries, the long-term capital gain is not completely forgiven typically, but it is definitely a deferral. You get part basis back, and you do get some capital gains back when the distributions come out of the trust. And then another benefit is any assets that are in that trust are not subject to estate taxes upon the death of the beneficiary. And typically you get a charitable deduction on the creation of the trust as well. If we'll turn to the next page, the next slide, that just kind of shows the diagram there, what we just talked about. You've got the donor on the left makes a gift into the trust, payout for a term. In this example, it's 20 years at some percentage, and it doesn't have to be 6%. That's just an example here. But let's say 6% gets paid out over 20 years to the individual beneficiaries. But let's say during that period, the assets have a return on investment of 8%. Well, at the end of the the 6% gets paid out to individual beneficiaries. And if the assets grow at more than 6%, there'll be a balance at the end of the trust, which gets paid down to the giant heart there, which is the charity. Next page on charitable lead trust. This is the type of trust we talked about earlier, so I won't go into this too much, but it's important to know that they can be structured in different ways. For example, a unit trust or an annuity trust. The main difference there is that with a unit trust, the payout is a fixed percentage. In other words, the charity is going to know, it's a fixed percentage of the assets of the value of the trust. So the actual payout can fluctuate. Now remember, in a charitable lead trust, the charity leads, so the charity is getting the distributions first. So one downside from a charity's perspective is that the amount they get will fluctuate every year, depending on the value of the assets in the trust, because the unit trust is going to say pay out, say 6% per year. Well, if the value of the trust is $100,000, the charity gets $6,000. But if the value fluctuates and goes up to $150,000, the charity gets $9,000. But conversely, if there's a bear market and the value of the trust goes down to $50,000, then 6% of that is only $3,000. So there's some uncertainty, which a lot of charities prefer not to have that fluctuation. So the annuity trust solves that problem. The annuity trust is a fixed income amount regardless of the size of the trust. So the trust could fluctuate up and down as much as possible, but the amount paying out to the charities is going to be the same. The only kind of downside there from the charity's perspective is that over time, if there's a long and extended bear market and that fixed income, that same amount is being paid out every year, it could end up draining the trust, and the trust might end before the expected term, meaning two things, meaning the charity doesn't get the income for the entire amount of years, and also meaning that there's not anything left for the remainder beneficiaries, which would be the individuals. These trusts, I think, as we said earlier, can be done during life or can be done at death, which we call testamentary, either through a revocable trust or through a will. And then if we'll turn to the next slide, there's kind of a diagram there of the charitable lead trust. You'll see the donor makes a gift into the trust. In this case, it's just the reverse of what we saw earlier. There's a 6% payout to the charity over 20 years. And then if there's money left, in other words, if we have an 8% return on investment, then what's left goes to the individual beneficiaries. And so it's a way of getting assets out of the donor's estate, but still leaving and doing some charitable good and leaving money to the beneficiaries at the end of the term of the trust. And that's all I have on trust. We'll go to the next speaker.
All right, thank you. So one of the larger sections of this presentation today is on acknowledging and stewarding planned gifts. And you might be asking why your response would be different from what you do for your other donors, for major gift donors, for instance. It is different, and we will discuss some of why here as we go through this. On receiving, let's talk about two different things. One of them is on receiving a matured planned gift, which is an interesting way of putting that. And then on the other one we'll talk about in a minute is on receiving notice that you're in somebody's estate. So you receive notice that you have been the beneficiary of somebody's generosity. That person is deceased. Say you received a $100,000 bequest. The first step I would say is to do your homework and find out everything you can about the donor and why that gift was made. That's not always the easiest thing to do. It's possible you will receive a gift and you will have no information whatsoever about that donor. One of the largest gifts, planned gifts received at the university was from somebody we didn't know at all. $2.1 million to create a scholarship fund. And we had no information about that person. So we turned to all the possible contacts. We contacted the attorney to get all the information we can from him. I have talked with executors in the past who were more than happy to share information about the donor. And if there's family, have that conversation. Sometimes the family does not know that your organization was going to be a beneficiary. And so it may be possible that you have the opportunity there to educate the family as to why this is important and to reassure them that the money is going to be wisely used. And then I'd say thank everyone. And you can't thank people too many times. And very often no one ever says thank you to the attorney. So they are surprised sometimes when they get a written note, and I have received notes in return or phone calls saying thank you. This is the first time this has ever been done. But make sure you say thank you to everybody that is involved in the settling of the estate. And then for your organization, honor any restrictions on the gift. It may come across with absolutely none, in which case you can find the best possible use for that gift and share that with the family. This is your opportunity to bring them into the fold of your organization. If there are restrictions, for instance, that $2.1 million at the university, honor those. So we created the scholarship. It's going to bear the donor's name. It is being used, and we share any of that information with living relations. Then if you have a legacy society, and we're going to talk about that in a little bit as well, make sure you add that donor. Make sure the family knows that you're going to be honoring that donor in perpetuity as well. It is a way for that name to go on forever. And then where it's appropriate, do a press release. If you've got a newsletter, write the article, tell other people what has happened for your organization. That's a value that helps encourage others to consider the possibilities of doing the same. All right, now on a different note, on learning that somebody has included your organization in their estate plans. These are possible responses, and you always have to consider that this donor could become your largest donor. So when I receive any information that somebody is including the university in their plans, whether they document it or not, whether they just tell me at a cocktail party, whatever it is, I make sure I follow up with appropriate calls or visits, and I say thank you. And if it's appropriate at your organization, have a call or a letter from the president. Make sure that the top person is also saying thank you. And I would argue easily that a planned gift, as possible transformational gift that these are, that is an appropriate letter to come from the president. If you've got a planned giving society, here's a chance to send the welcome packet. Has the information on why they're getting in to that organization. Sometimes people aren't real sure what that means. So here's your chance to explain it. Add them to your birthday or holiday or other card lists. In all the organizations I've been involved with, we sent out birthday cards to donors when we knew the birthdays, sent out a thank you, appropriate, Thanksgiving type of holiday card, whatever it is, and make sure you include them on that list. Go ahead. Give them a small but unique gift. We have some places give a certificate. I've seen people give pens, stick pins, lapel pins, glass bowls, whatever is appropriate for your organization, but make it unique. You don't want to give them something that they can get for giving a major gift or giving an annual gift, something unique to your planned giving society. Again, write about them. Here's a chance to tell their story. And then this is a strange way to say thank you. I realize that, but ask them for a gift. You have an opportunity here. They are fired up about your organization. They have shared with you that you are in their plans. They have possibly elevated you to the same level as their children. So they're not going to be much more excited than they are right now. So it's an opportunity for you to make an annual donor out of them. Or if they've created plans for a scholarship, this might be a way for you to get them to start making a gift now that will enable that annual scholarship to begin while they're around to see it. They don't have to wait until they're not around anymore for their scholarship to begin. So it says, and every year. Okay, this is where some of the difference is between your major gift donors and your planned gift donors. We're no longer looking at a window of one major gift to the next major gift. We're looking at a window of 2 to possibly 40 years that you're going to be stewarding these donors. So you might consider something small, a little reminder every year. We've sent keychains, sent pens, we've sent little bags, whatever it might be, something small for the members of your planned giving society. And then I would encourage you to invite them. I hope there's an annual planned giving society event of some sort, but other events as well, and find a way to recognize them. At the university, having done our annual luncheon for a decade, we decided to try something different and lined up for events for 2020. Now, obviously, most of those did not take place, but we were going to highlight the members of the Column Society, our legacy society, at each of those events. There was going to be a movie shown in music. There was going to be, I believe, an art exhibit. There was great conversations, some sort of event with athletics. And we were going to have special invitations to this group and find ways to recognize them at those events. And they were excited about it. So I hope that is something that might come to pass down the road. Another opportunity is to send an annual report of some kind. Either here's what you've done, or here's what you will do with your planned gift. You have the opportunity to take them to lunch, coffee, happy hour, whatever, every year. So you're treating them like your own other donors, perhaps in that manner, but better. As I said, a planned gift donor is going to need stewarding a lot longer than your major gifts donor, and planned gifts are mostly revocable, meaning that they can change that if they become unconnected to your organization. So I encourage you strongly to plan your moves. Make sure you know what you're going to do. Make sure you know how that group is going to be treated. All right. So here's a typical timeline for major gifts. You have identification, cultivation, solicitation, and stewardship. Maybe that takes place over 6 months, maybe up to 2 years, but that's the typical timeline. But let's look at one for planned giving. You got the identification, cultivation, solicitation, and then stewardship goes off the chart because you're looking at 2 to 40 years possibly. If you have a whole lot of people these days that are making their first planned gift in their 50s, their first commitment. So you have the potential there for 30 to 40 years before that gift could possibly be realized. All right. Continuing with every year, one caution is don't focus on only one person in a couple. You need to try to engage both of them. Very often, and this is not sexist, this is older donors and older couples. The male may have made some decisions about philanthropy that the wife was not a part of. There was no consideration there. And so at a later date, at a great percentage of the time, it is the female who is going to be the one making the charitable gifts. And if you have not engaged both parties, you may not get that gift. And I would advise to give opportunities to keep learning and for them to keep learning and upgrade their estate plans. We've had at the university, we would have programs on planned giving and on ways that they could make gifts. We had some donors that would come back to us that had originally made a gift of a certain size and it was now going to increase. So the more they learn, the more they're going to have an opportunity to expand their gifts. And if there are other great ideas, I'd be very interested in what you have to say. If you put some of those in the chat box, maybe we can revisit those later on or share them at a later date. All right. Planned gift societies. I am an advocate for those. I am an advocate for being extremely inclusive and welcoming anybody with open arms. Somebody can come up to me at a cocktail party and whisper in my ear that my organization is included in their estate plans. They are now in the Column Society or whatever the organization's planned gift society is. Make it the easiest one to get into. People don't lie to get into your legacy society. I will say though, being inclusive does not mean you have to treat everyone the same. We had a program a few years ago with a speaker that was talking about the fact that your planned gift society may have donors that have just shared with you that you're in there, and then you've had the donor that has shared that you're in there for $1.5 million. You don't have to treat those people the same. You need to perhaps find ways that the people that share that financial information with you are getting a higher level of attention perhaps. However, I would say don't treat any members of your legacy society as second-tier donors. Now you say, oh no, we would never do that. So how about this scenario? Mary Gotrocks, age 70, makes $1 million gift to your organization. She immediately is recognized as a member of your Big Bucks Gift Society, probably every year, will likely have a press release. Perhaps her name gets tattooed on your president and your development officer is going to follow her around at all of your events. On the other hand, her sister, Susie Gotrocks, older sister at 75, signs a statement of intent and provides a copy of her will that states that the organization is going to get $2 million at her death. She gets listed in the Legacy Society, probably gets to attend the luncheon every year, does not often get publicity, and her name's probably only a temporary tattoo on the development officer. She feels that she's made at least as large a commitment as her sister, but the organization doesn't typically see it that way. Is Susie a second-tier donor? No. Shouldn't our recognition and stewardship of someone like Susie be well in advance of her death. All too often, we end up thanking our donors' estates and may miss the opportunity to connect with her on a deeper level or her family. So I encourage you to make sure that you're honoring your legacy society while they are living, while you have that opportunity. All right. No, sorry. Go ahead. So other things about your legacy societies. They're often, how you choose to name them is important. Sometimes they'll use some historical event. They'll use a major donor. I would encourage you not to use a living donor in those cases. Other options could include a phrase of some sort or a landmark that's important. Like on a college campus, there might be bell tower or something like that. And I listed a website there that has a little conversation about choosing legacy society names by Russell James. And so I have great respect for his research and would suggest you check that out. If you're just now creating a recognition society, a good selling point up front would be to honor the founding members. And maybe they get the bold print for the forever. But that gets those people excited at the beginning and helps you get started and get your foot in the door. Again, make it the easiest gift society to join. Have a special event for this group and special gifts. Go on. And then this is a topic I don't want to spend a lot of time or go into a lot of depth on. Most organizations are just going to take planned gifts, especially smaller ones, and be happy when they come in. It's going to be just a moment of celebration. But as far as counting them on your books or in your metrics as a development officer, as an organization, are your planned gift donors fully recognized? Because they, like the Gottrocks, they consider that their gift is as important and at the same level as the major gift donors. And as for your development officers, do they really want to work on raising gifts that aren't going to be recognized by the organization? So I think all organizations need to have some metrics for planned gifts, but I would encourage you not to use dollar amounts. Use visits, the number of statements of intent obtained, number of proposals made, those sort of things that are good measures of the activity. But all too often, we don't know the size of the planned gift. They're going to tell us it might be a percentage, or they're not going to be willing to reveal the amount, but you need to be able to be measured for your productivity without using dollar amounts. All right. And if you're having a campaign, you've got to have planned giving as part of any campaign. It's short-sighted not to include it. These are times when you're having very personal conversations with your donors. There's the general excitement of a campaign that helps generate gifts like this. A lot of planned gifts go to endowment, and a lot of people prefer to give to an endowment. So you need to have that as an option. And then there's a deadline. The campaign is going to have an end point, and I have found that statements of intent that I could not get during a campaign, when that artificial deadline showed up, all of a sudden those came in. So a campaign is a valuable tool for getting planned gifts, and planned gifts can be a large portion of a campaign's totals. I think the general rules that I see these days are anywhere from 15 to 30%. But I've heard of exceptions where it was even more than that of the campaign total. All right. So this is the University of Memphis confidential statement of intent, and you can go online and find 50 other ones. But this is an opportunity for your donor to be able to share information with you, and an opportunity for you to collect a lot of valuable information about the gift and your donor. So in this case, it's got the donor can check how they are including the university, what kind of gift it is, and then very important is you want to be able to make sure that your organization can honor the wishes that they make. So when they tell you what the designation for the gift is, it may be something that you can't do, or that you need to help them rethink a little bit. Somebody comes in and they're bound and determined that they want to create a scholarship. Well, in the end, you find out what they really want is to make sure they are honoring a professor or their parents. And so there are perhaps better ways for them to do that. It gives them the opportunity to put an approximate amount of the gift, and then it gives crucial information about them, including the date of birth. You always want to make sure you collect that and get that into your database. At the bottom, one second, at the bottom of this one, it says the amount of your gift always remains confidential, and the university is going to recognize your membership in the Column Society. So it gives us the chance to say, here's what we're going to do. Based on this, we can say thank you. And then under certain circumstances, we can actually book certain gifts. If you go ahead. Thank you, Sarah. But I'm not going to try to get into how to count planned gifts in your campaigns or whatever. I strongly suggest you check out charitablegiftplanners.org. That's the national organization for our Planned Giving Council is part of, and enter gift counting in their search feature. It will provide a huge amount of information. All right. And so final words here on this would be to follow the national standards, and whatever you decide, if you decide some parts of it are going to be different, that's fine, but be consistent. This is not something you change every year. You want to be consistent throughout the long term. When you can, document a commitment with a statement of intent. I've had donors that when I asked them for that initially, they said, Dan, that's crazy talk. But after a couple of years or in getting involved in a campaign, they came around to see the value of that and made sure that they got their statement of intent done. Just going to say that all planned gifts are not deferred. So you need to be marketing all kinds and marketing it to all of your members. Insist that your measurements of success emphasize more than dollars raised, and stick with this. This is not something that's a flash in the pan. You may wind up with your transformational gift from a planned gift donor. So even if you don't see instant results, say within the first couple of years, it's going to come. So stick with it. I think that's all I have. Thank you.
So next, we're going to talk about meeting donors' wishes. And I think, listen to what Dan said, for a current gift, it's going to be a lot easier. There may be a shorter time frame. For a planned gift, it's going to be a much longer time frame. And also, the industry is unique, especially Dan talked about earlier. Somebody leaves you in the day, and these gifts may be more about like to who your best candidates are. That's your annual fund. Meet with them, ask them, what do they want to accomplish? What do they love about your organization? How can their gift help your organization? You really want to talk to them about what's important to them. And gifts could be the things that they've ever made in their lifetimes. They're going to have definite thoughts about this. I used to think like giving was all about convincing donors to donate to my organization, but realize that a lot of it is learning what kind of legacy they want to lead and really learning what's important to them. Thinking donors are going to have some restrictions they want to place. And so we're going to talk next about restricted and unrestricted gifts. So unrestricted gifts are easy. In this first example, I say I bequeath $5,000 to Le Bonheur Children's Hospital Foundation. Whenever we receive that gift, we can use it for whatever we need. However, as Dan was talking about, some donors are going to put restrictions. So I use the next example. I bequeath $5,000 to Le Bonheur Children's Hospital Foundation for research related to COVID-19. That would be a difficult gift even for a current gift. There are very few organizations in this that are doing COVID-19 research, and if you're not doing it, $5,000 isn't going to be enough to start that kind of research. even more difficult gift if you look at planned gift, because as Dan was talking about, somebody will not die for 40 years. So you receive 40 years from now. Hopefully we won't be doing COVID-19 research in 2060. And so I've added some language here. Limited research or any research to say at this time that's not a gift that they can use for that purpose, and they can use it for another purpose organization needs. So I think a lot of that is just really talking to your donor and making sure they understand what works for them and also what works for the organization. And we want to make sure when we look at restrictions, that they are restrictions that something that fits with your mission. You know, you don't want somebody to give you a gift restricted to something that's not something you're already working on with your charitable purpose. And also, you really want to talk to that donor and make sure that they work for you and work for them. I had a donor who I just love, and he loved the food pantry that we have on a particular floor, and he wanted his gifts just to go to help that food pantry. And you know, I can't do that restriction. There's no way that we can limit it to that extent. And so we were able to not make that be happy that we can manage. And so there are some ways, you know, I've heard different stories about people saying, you know, the gift that for the or the throwing off $500 a year, which isn't really helpful for college students with the cost of tuition. So there are some ways the court can go in and broaden those restrictions or lift those restrictions. But obviously, if you need that on the front end, that's going to be better. And so we know restrictions can be important for donors, but we also want to make sure it's something that works for organization. Sarah, can you go to the next slide?
Yeah, Kathy, you're actually breaking up for me.
Okay.
So I heard like every other word, but your slide was very informative, so I could follow.
My slide was informative. So is this any better or it's still bad?
That's better.
Okay. I'll try and speak a little closer to the camera. I apologize. I came to work so my internet would be better, and apparently that's not been the case. So next I'm going to talk about difficult assets. And so gifts of real estate we talked about earlier, they can be a great gift, but you can also have somebody offer you a piece of land for 5 years. Or not working.
Not working.
Okay. Why don't we go on to Carlisle? Why don't we go on to you and Mike's parts? Because I don't want to keep talking if it's breaking up. And I'm again and see. So y'all do yours, and then we'll see if it comes back. I apologize, everyone.
Okay.
All right, Sarah, if you'll skip forward to the probate
Basic
process.
Yep.
Perfect. Thank you.
You're welcome.
All right. Yeah. So what I'm going to speak with you guys on today is the probate process, and what that process really is how, you know, what's relevant in this presentation is how is a charitable organization ultimately going to receive a request under a will. And so I'm going to try to discuss this process without going too much into the legal particulars, but I do want to point out the steps through the process that are relevant to charitable organizations as beneficiaries of a bequest. Because it's going to be likely that any charitable organization is going to have to experience the probate process at some point. It's good to have a general understanding of what to expect throughout this process and what your rights are going to be as a beneficiary of an estate. But whenever I begin to discuss the estate planning process or the probate process, I always start by explaining the 3 ways that assets will pass upon a person's death. So the first way, and this is going to help you understand kind of what asset can eventually become bequests anyway. But the first way that assets can pass upon a person's death is that they are jointly owned with what is called a right of survivorship. Those types of assets are going to pass to the surviving owner or owners at the death of one owner, and that's automatic by operation of law. And so secondly, you have assets that pass by beneficiary designation, as Mike's discussed, and he'll discuss in greater detail later. But those types of assets are going to pass to whoever the account owner has designated as the beneficiary of that asset. So both of these types of assets, jointly owned and those that pass by beneficiary designation, they don't require any type of probate proceeding. So generally speaking, they're more likely to pass quickly to their intended beneficiary. In addition, these assets are going to pass to the designated beneficiary or the surviving owner, despite what an individual's will might say. So only assets that are in a person's sole name or that are payable to their estate are going to pass pursuant to the terms of their will. And these assets are required to go through the probate process in order to be distributed to the beneficiaries in the individual's will. So like I mentioned earlier, Mike's talked about beneficiary designation a little bit. I'm going to talk about it more later. But as we'll see, it can be an efficient and useful tool for passing assets to a charity in comparison to a will. As I mentioned, a person has to pass away in order for their will to be valid. And so in order for those assets ultimately passing under the will to pass to the designated or intended beneficiaries. It's also important, I think, to ensure that advisors and professionals can ensure that a client's assets are aligned with their wishes in order to ensure that that individual or that client's wishes are met. And kind of what I mean by that is I gave an example earlier. If the client has several bequests under their will, but they don't have any assets passing under the provisions of their will or through their estate, those bequests potentially will go, unmatched because there won't be anything for the charity to receive under the will because there are no assets passing through the estate. So we just want to make sure kind of if there are no assets passing through probate or passing through an individual's estate, that maybe beneficiary designations will satisfy those specific distributions to charity that a beneficiary or an individual wants to have at their death. So the type of gift is also going to play an important role in determining the timing of the gift, more so than the process by which a charity is going to receive the gift. And for instance, a charity designated as a beneficiary on life insurance or a brokerage account, there are no time limitations. That gift can be received by the beneficiary as soon as the account owner dies. The beneficiary completes the paperwork to receive that asset, and that paperwork is approved by the financial institution. On the other hand, the same asset passing by bequest under a will may take 6 months or longer to get to the charity. As we'll see, this is a result of the 4-month creditor period or claims period, which is required for all probate estates in Tennessee. And this length of time can obviously be extended based on the circumstances of the probate proceedings that are relevant. And you're fine, Sarah. We can stay on this slide for a minute, so I'll let you know when we need to move along. But just to give you kind of another example of types of assets, I'm currently handling a trust administration, and this is generally supposed to be a more quicker estate administration process in comparison to a probate proceeding. But in this trust administration, the charitable organization's actually the recipient of 30 or 40 mineral interests throughout Oklahoma, Texas, and Louisiana. And this is actually my first time to deal with mineral interests. But it's been a long and kind of cumbersome process because we've had to do research into the various interests and work with attorneys in these different states in order to get the interest from the trust to the ultimate charitable beneficiary, who's actually an organization here in Shelby County. And obviously, I believe that the charity would have probably preferred to be a beneficiary of this decedent's $500,000 brokerage account, which was paid out 4 months after the individual passed away. in comparison to these mineral interests, which are still in the process a year later after the decedent's death, are still in the process of being transferred over to the charitable organization. Additionally, these interests are generating such a small income stream. It'll probably be at least 2 or 3 years before the charity actually sees any kind of benefit from this bequest, simply because of the expense that's been involved with transferring these interests to them. And finally, kind of the another point of that story that's it's important, as Dan mentioned, for a donor to work not only with their advisors but a charitable organization before putting together a planned gift or a bequest and an estate plan, simply because things like this can be avoided. We can match, the donor's intent and their plan with their wishes, and we can do it in a manner that works well for the charitable organization. Okay. So kind of moving on to the next slide, to begin the discussion of the probate process, I first want to mention that charitable organizations are only going to be beneficiaries in a probate proceeding where they receive a bequest under a will. There is an intestate probate proceeding that only occurs when an individual dies without a will and their assets pass to their next of kin as provided in Tennessee law. So really, we're going to be focusing on when an individual dies with a will. And when I discuss the probate process with a lot of people who aren't familiar with it, they're oftentimes in fear of it, and they think it's kind of this arduous and difficult process that they never want to experience. So probate avoidance, at least from my perspective, or maybe the perspective of a lot of our clients and beneficiaries, it's often preferable to avoid it if at all possible. But the probate process isn't always the most difficult, depending on the circumstances and depending on the assets involved. For every estate administration in Tennessee, there are several steps that the personal representative must follow. And generally speaking, these tasks are relatively easy. So I'm going to try to focus mainly on the steps, again, that are relevant, particularly to charitable organizations or charitable beneficiaries. All right, so kind of moving on to the discussion of the will. When we're discussing an individual's will, a will is actually not deemed valid until a person passes away. So a will can always be changed during an individual's lifetime. So this gives an organization or an individual the opportunity to become, or for an individual to become a potential donor or a donor for an organization, because a will is not set in stone until a person passes away. So generally speaking, to initiate the probate process, the executor that's named in the decedent's will must hire an attorney and petition the court in the county where the decedent passed away to have the will admitted to the probate process. So if a judge determines that the will that's been presented is valid, they're going to admit it for a probate administration, and then the executor will be admitted, or will be issued what we call letters testamentary or letters of administration. And these letters are really just the executor's kind of ticket to show that they have authority to act on behalf of the estate. This allows them to collect assets and go through the process of dealing with various financial institutions and beneficiaries. The executor must also work with his or her attorney to complete the administration, which generally just ends up with the distribution of assets to the beneficiaries designated in the individual's will. So just to kind of touch on a couple of the steps that are required in every probate proceeding in Tennessee. The first will be that the personal representative or executor of the estate might be required to post a bond, which essentially will just be insurance on the value of the assets of the estate. And obviously, this can be important or helpful if the executor mishandles the funds that come into the estate. Next will be that an out-of-state personal representative will have to consent to the appointment of the Tennessee Secretary of State as their agent for service of process. And this is simply that in case the estate becomes involved in litigation, that there is an agent who can accept service of process for any type of proceedings that may be involved with that estate. All right, so what are some of the more important requirements for a charitable organization. So within 60 days of an estate being open, an inventory must be filed with the court. So unless this requirement is waived by the court or the will. But what an inventory is just a list of all the assets that come into the estate. And that can be important so that the beneficiaries have an idea or know what to expect in terms of distributions and a value of the estate. Kind of one of the next requirements is that each beneficiary under the will must be sent a copy of the will and notice that the estate has been opened within 60 days of the estate being open. And then finally, TennCare must be notified of the proceedings, and a waiver is going to have to be obtained from TennCare before the estate can be closed with the court. Now, I think the important thing to note on this slide is that a charitable organization, if they're going to receive or be a beneficiary under decedent's will, they're going to receive a notice of that bequest. With all the 60-day requirements, however, and other issues that we've discussed and will continue to discuss, that does not mean that a beneficiary or a charitable organization is going to receive a check shortly after being notified of the opening of the estate. It's still going to be or potentially be a long process. Notice of the bequest from the attorney can be useful. From the planning side, I've kind of always assumed that being a direct beneficiary of an asset, passing by beneficiary designation would be most helpful and easy for a charitable organization. However, I've come to understand that, and talking with Kathy about this presentation, I've come to understand that not all financial institutions actually give notice to their beneficiaries or the beneficiaries designated on particular assets. So that can obviously make assets under which an organization might be a beneficiary difficult to find and recover. So notice, obviously, of this process and being a beneficiary of a bequest can be somewhat of a relief and a little bit easier for a charitable organization. All right, so now I'm going to kind of talk about the main and probably most difficult or time-consuming process of a probate proceeding, and that's going to be the creditor's claims procedure. So after a personal representative is appointed, they're required to send notice of the opening of an estate to any known or reasonably ascertainable creditors of the decedent. Notice of the opening of the estate is also going to be published in the local newspaper by the clerk's office. So upon receipt of actual notice from the executor, a creditor has 4 months from the date of which notice is first published to file a claim, what's called a claim against the estate. If the personal representative does not agree with that claim, they have 30 days to file an exception to that claim. If an exception is filed, a hearing is going to be set for the parties to dispute its validity before the court. If no exception is filed to the claim, then that claim is going to be assumed to be valid and it must be satisfied before the estate can be closed. So as you can see, there's a lot of kind of legal procedures involved with the creditor's claims process. And depending on the number of claims that are filed, it can be time consuming, expensive, and difficult simply because you may have several different claims that an estate may have to combat throughout the administrative process. So what are the priority of expenses and claims that are going to be filed, or of claims that are filed against the estate? So the first are the costs of administration. So that's going to include legal fees, bond premiums, and a fee of the personal representative. The second is going to be funeral expenses. The third are taxes, federal government assessments, and TennCare claims. And then the final priority of claims is actually any creditor claims that are validly filed. And so those are last in the order of expenses and claims. But if funds are not sufficient to pay all the claims, then the estate may be deemed insolvent. So what that
I think
means,
Mike wanted to add something.
Okay, go ahead, Mike.
Hey, Carl, I just, on the timing of the creditors to file claims, wanted to see if you'd touch on, sometimes it goes even beyond the 4 months for 1 year. And just in your experience, do executors sometimes, are they sometimes hesitant to release the charitable bequest even after the 4 month period? Because if some creditors don't receive notice, they have even longer than the 4 month.
Right, and I didn't really get into that, Mike. That's a good point. It's because it gets a little more complicated depending on whether or not they received actual notice and when publication was made. So, yeah, I mean, generally we'll at least wait. We could potentially wait up to a year if notice wasn't published, just for that very reason, depending on what the bequest might be and what the value of the estate is. So, for any estate, or for any decedent in Tennessee, if there's no estate open, creditors have a year to force open a decedent's estate. So if there's a large claim, they could actually force open an estate even if it's not open. So they can potentially get assets that actually don't even go through the estate. So yeah, it's just going to depend. So that's why it's vitally important, I think, and Mike, you probably agree, that for any executor to notify even creditors that you might not think have a claim, so that you can start that 4-month period.
Right. Yeah, I agree. And because if the executor wants to timely administer the estate and get those charitable bequests out, I believe they have to give actual notice to any creditors that they know about or reasonably could know about. And so it's always better for if the executor would be proactive and err on the side of caution, it would allow the executor to feel more comfortable that there aren't any claims out there, that they've given notice to every possible person, just meaning that the charitable and non-charitable beneficiaries can receive those bequests sooner.
Yeah, exactly. And, we've had instances where we were unaware of a creditor, but then they filed a claim, and we'll actually send them a notice after they filed a claim, just so we can kind of have a date where we can start that notice period, or start that 4-month clock, depending on when the notice was given. But yeah, for sure, definitely you want to err on the side of caution and send out as many actual notices as you can. All right. Anything else you want to add to that, Mike?
No, I just kind of wanted to make that point that, because charities are often wanting to know, well, when are we going to receive the bequest? And, they have to at least wait the 4 months from publication. But I wanted to be clear that sometimes it's reasonable to have to wait, even longer than that, depending on how proactive the executor is, how experienced the attorney is, and whether they've given that notice. Because I've seen people just say we're going to wait the year just to if they're really conservative or paranoid.
Yeah, I guess we're probably not that conservative, depending on the circumstances. Because usually beneficiaries and executors are frankly in a hurry to get everything wrapped up, I'm sure, as you're aware. So we try to if we think everything's been done reasonably, and we're certain that notice has been given, we'll try to wrap that up before the year, if we can. But yeah, it's just going to depend on the circumstances, more
Right.
often than not. So,
Right.
Yeah. And then that's another good point as well. So a lot of beneficiaries think, the creditor period or the 4-month period starts when the estate is open. It actually doesn't start until notice is published, which may be another month after the estate has already been opened. So that's going to delay things as well. So it's just kind of, there's a lot of moving parts and a lot of dates and things like that to have to keep up with. All right, so I think that we can move on now to kind of the next and kind of the next biggest requirement of any personal representative, and that's going to be the filing of an accounting. So this can be waived by the beneficiaries, but a personal representative or executor is required within 15 months of an estate being opened to file an accounting, which is basically just, it's a document that tracks all the assets that came into the estate as well as the distributions that were made from it. So it gives the beneficiaries and the court an idea of everything that went on through the estate administration. This can also be, if the estate needs to be closed prior to that 15-month window, it can be required by the court before closing the estate. However, we often try to have beneficiaries sign what's called a receipt and waiver, which is just an acknowledgement that the beneficiary has received their full share from the estate, and that they waive the requirement of an accounting, and the court will often accept that in lieu of a final accounting when the executor goes to close the estate. But this can be a helpful tool, if a beneficiary or a charitable organization thinks that the executor hasn't adequately or properly administered an estate, so that they can, get a full record of whatever, what's been done, again, what distributions have been made and things like that, so that they can ensure that they have received their share. And so, that the waiver of that requirement isn't something that's required in order for a beneficiary to receive their share. I'd also like to mention here that probate proceedings are public record. So the fact that, you'll receive notice of the opening of the estate and the will, the will will give you the terms of the will, obviously, so you'll know what your share is going to be. And any filings, at least in Shelby County, will be online. So anything that's filed in a certain probate proceeding, you can access because it's public record. So, I think that's important for charitable organizations to keep that in mind, and also to make it a good practice to follow up with the attorney of a donor's estate on a regular basis once proceedings have been started, so that they can keep abreast of everything that's going on. All right, and so just a couple of other things that I'll mention here. The closing of the estate, that's just simply done with a petition that's filed with the court. And if everything is in line, if receipts and waivers have been attained, accounting's filed, and everything looks good in that regard, all the kind of requirements that we talked about earlier have been satisfied, affidavits in that regard have been filed, assets have been distributed, creditors have been satisfied. The executor is going to outline that in the petition, present it to the judge, and then the judge can enter an order allowing the estate to be closed. And at that point, the executor has no authority to act on behalf of the estate, and the estate administration process is complete. And so if assets are subsequently discovered after that, after the estate's been closed, the personal representative can request or ask the court to reopen the estate. That's again just done by the filing of petition. And once that asset that's been discovered is handled, the estate can be closed as soon as that asset's been administered through the probate process under the terms of the decedent's will. So then it can be closed in the same manner after that. And so that's kind of the probate process in a nutshell. And kind of one thing that I just wanted to add, in addition to what Dan mentioned earlier, from a planner's perspective, and I say probably 3/4 of my clients who end up putting charitable bequests in their documents, they don't even notify an organization that they're putting that organization in their estate planning documents. So I think it's vitally crucial that for those types of donors, as Dan mentioned, to follow up with the executor, with the trustee, with the family, with the attorney, to thank that donor and their family, one, and the attorney, but in addition to kind of cultivate those relationships, potentially, that could potentially lead to, new donors from that individual's family. And you can also have a future relationship with that attorney so that they have somebody maybe that they can contact in the future, or that you can contact in the future to discuss potential donors and their estate plans and things of that nature. So I kind of just wanted to piggyback off that thought and give my 2 cents from a planner's perspective. But like I said, that's kind of all I have on the estate planning process. And so now we'll kind of move into the timely receipt of gifts. And Mike's going to talk about that process and go into the beneficiary designation area a little bit more as well. So Mike, I'll turn it over to you.
All right, thanks, Carlisle. And before we move on to that, I wanted to ask you, Carlisle, one kind of question on the reopening of the estates, because you touched on that. Oftentimes you have the executor is really anxious to close the estate and say, I'm tired of this. I want to be done. Let's close it as soon as possible. Sometimes do you tell them, look, we're done, but let's wait 2 or 3 months just to make sure some asset doesn't turn up? Because it seems like every time I close one as fast as you can, 2 months later, they find some other asset. And then, I mean, not that that's the end of the world. As you said, you can reopen the estate, but it involves additional legal fees and court filings. And so I was just curious, do you typically advise them to kind of keep it open an extra few months rather than just close it immediately?
Yeah, for sure. And it depends on the executor. Again, in the nature of the executor, if they're more willing to kind of hold off. I mean, once everything's been distributed, there's not really any hurry to close the estate, other than for the executor to be done with it. There's nothing else for them to do. They don't have to make an additional court appearance. So it definitely is not a bad idea. Because like you said, I mean, it happens more often than we'd like for an estate to be closed, and then 3 to 6 months later, executor comes back and say, "Oh wait, I found this bank account," and then, it's generally an asset that's going to be small, and it's just going to be kind of more of a hassle than anything. So if you can convince the executor to keep the estate open for a little bit, especially if you're within that accounting period, and all the beneficiaries have signed receipts and waivers, there's really no downside to leaving it open. Nobody's doing anything. You're not incurring legal expenses. You'll save 2 more court appearances. So yeah, that's definitely a good idea, I think. Again, if you can convince the executor.
Right. And that's always the challenge, to explain to them the cost benefit, because a lot of times they want to say, I want that order say I'm no longer the executor, because that means I'm no longer liable for anything. So.
Right, exactly.
All right, well, let's move on to how some assets pass outside of probate. We're going to talk about some during life. Well, really, this is actually timing of the gifts as well as non-probate bequests. So we're going to first kind of talk about the timing of gifts during life versus at death, and then talk about different ways at death that assets can pass outside of probate. So moving to the next slide, during life, we're going to look at several different categories here. Checks, for example, typically follow the mailbox rule. And the mailbox rule means when it's postmarked by the post office, not when someone stamps it in a postal meter in their office. That is not binding. But if there's a postmark by a post office by December 31st, then for the charity's reporting purposes, they should report that gift in that calendar year, December 31st of the prior year, even though the charity may have received it, say January 3rd, or in this day and age, the way the post office is working, maybe January 15th by the time they get it. It seems like FedEx and the Postal Service have really been slow during COVID and even prior to that. So it's important to look at the postmark, not the date of the check and not when you received it, but the postmark stamped by the post office, because the charities are required to report that gift to the donor. And to the next slide, the next category of gifts are kind of easier, I think. If it's a credit card or if it's a text message, and we're on the next slide, Sarah. If it's a credit card or text message, it's just basically when the charity receives it, or technically it's when the donor becomes indebted to the credit card issuer, which is typically going to be the same day that the charity receives it. So if you're receiving something via credit card or PayPal or even text message these days, that's going to be pretty much the day you receive it, is the day you report it to the donor. Then moving to the next slide, we're going to talk about tangible personal property. The delivery of tangible personal property is generally when you receive it, although sometimes personal property is going to have something like a title, like a car. And in that case, the charity has to both receive the actual tangible personal property, but also the title showing possession as well. And we've cited a tax court memorandum opinion there In rare cases, constructive delivery can be shown, but typically you're going to need to receive both the property and the title to that property. Real estate, there's a similar kind of catch there. If someone hands you a deed to the property, that's really not complete until that deed is recorded, because they could go and prepare another deed and record it, giving it to someone else. So it's important for any gift of real estate to have a deed, but to have the deed recorded. And so if they give the deed to you unrecorded, you need to make sure you get recorded in the county where the real estate is located in the Register of Deeds in that county. Typically, I think that'll be done by the donor, but just to know that if you receive a deed that hasn't been recorded, you need to, and the way you'll know it's recorded is it's typically stamped by the Register of Deeds, that it's been recorded, the date that it's been recorded, or and sometimes that's on page 1 of the deed. In Shelby County, they typically kind of add a page on the back with all the recording information, with the instrument number and the date. If we'll look to the next slide, we're going to talk about investment securities, kind of 2 broad categories there. If a stock, if the donor actually holds the stock themselves, in other words, it's not held in street name, it's not held by a broker or a financial institution. They've actually got the piece of paper. The date on which that becomes complete is the date in which the transfer agent of the corporation reflects or makes the change to reflect the change of ownership on their books. And so that's important. If it's in street name, if it's held by a financial institution, that's easier. That's just the date on which the transfer to your account, to the charity's account, becomes complete. So on that one, you'll just wait until it hits your account, and that's the date it's complete for reporting purposes. And the next page, kind of the conclusion here, is you'll see the rules are complicated. In some cases, you may not know the exact date on which it was complete. And sometimes the day, for purposes of their deduction, is separate issue from when you book it. And so for that reason, the 3rd bullet point there says, you could state in your receipt that to the donor, your stock gift was received in our brokerage account on blank date. And then that kind of shifts the burden to the donor to have evidence of when they gave it or when it was complete on their end. All right, the next slide, we're going to talk about some gifts at death that don't pass through the estate. And what are the advantages and disadvantages to you, the charity, on something passing outside of probate versus through the probate process. And the first one is, like we were talking with Carlisle, the period for creditors to file claims is 4 months from the date of publication in the newspaper, or up to 1 year from date of death if a creditor doesn't actually receive notice. And so sometimes the charity or any beneficiary is having to wait a long time to receive their gift. So if something does not pass through probate through a beneficiary designation or through a payable on death designation, that completely skips probate and therefore is not subject to the claims of creditors, meaning the charity could get it much sooner. The problem, though, is finding out about it, because there's not really a quarterback typically of all the various beneficiary designations like there is an executor of an estate. So on the one side, you can get it quicker, but on the other hand, you have to first find out about it to be able to get it. The other advantage of not passing through probate is if there are not enough assets in the estate, in the probate estate, to pay all the debts of the decedent. I had one client a while back who was living a little bit beyond his means. He had about $100,000 estate in assets, which was mainly his home, but he had $130,000 of credit card debt. Now that's a lot of credit card debt. And in that case, there were not any charitable bequests, but had there been charitable bequests, or had life insurance been payable to the estate, or IRAs been payable to the estate, those would have had to have been used to pay those debts before any charitable bequest or before any individual bequest. So the two advantages of going outside of probate is the charity might be able to get their money earlier if they can find out about the bequest. And secondly, their bequest is not going to be subject to any debts of the deceased person. And let's see, yeah. And so then disadvantages continued. When we talked about that, it can be difficult. I think the first place to start is still with the executor of the estate or the attorney for the estate, even though that they're not really responsible for those assets. They're going to be the person that is looking through the decedent's papers, looking at tax returns, checking the mail. They'll be able to see if life insurance premiums were being debited from the bank account, so they will at least know that there is a life insurance policy and can go and look for that. So the executor and the attorney are not going to be as in the dark as a charity would be, particularly if the charity was not informed in advance as to be expecting the gift. And to that, I'll just kind of echo Carlisle's point that it's great if someone is going to make a charitable gift and they're working with any advisor, whether that's their financial advisor or their attorney or whomever, I would encourage them, particularly on a beneficiary designation, to let the charity know to expect that. And it doesn't have to be permanent. They could just say, hey, as of right now, I've named you as a beneficiary. That's not irrevocable. I may change it, but if something happens, just to know to be on the lookout for it, because it can be hard for the charitable organization to know about that. So after death, I would say check with the executor of the estate. Before death, if anybody involved could encourage the donor to let the charity know, that would be very helpful as well. So then next slide, we're going to talk about some examples, various different types of accounts that commonly have beneficiary designations. Retirement accounts, some people think, oh, retirement accounts are required to have a beneficiary designation. They're supposed to, but you might be surprised how many times the retirement accounts don't have a beneficiary designation. And if they don't, typically IRAs and 401ks and 403bs, all of those types of retirement accounts it's going to depend on what the plan says. Typically, the plan is going to say if there's no beneficiary designation, it's going to go to the decedent's estate. It'll be subject to their creditors. It'll have to be held for the 4 months. But every once in a while, you might see one that says it pays to the heirs at law, which means it just goes immediately to the next of kin. That's pretty rare because the plan administrators don't want to be responsible for figuring out who the heirs at law are. They want to just pay it to the estate, and that way they're safe. And it looks like Carlisle's mute is off. I'm guessing. Do you have some input?
Yeah, and I was just going to add to that, Mike. That's a good point, and that's also going to apply if the person has named a beneficiary, and that named beneficiary predeceases the account owner. So that's the default in that instance as well, is likely going to be whatever the plan administrator says. So generally speaking, the decedent's or account owner's estate.
Yeah, that's a great point. So Carlisle's point is that even if they did name a beneficiary, that beneficiary may have died before them and they never went back and updated and added another beneficiary, or there may not have been a secondary or contingent beneficiary. So there's really two ways it could end up in the estate. One is if they just forget to fill out the form or it gets lost, or secondly, if they don't update it. So yeah, so it happens. They go through the estate quite often, and particularly with retirement accounts, that's not a great thing, because then the estate is going to be subject, is going to have that taxable income from the withdrawal. Whereas if it had gone to a charity, the estate is not going to be subject to the income tax. Next slide, life insurance. All the same issues with life insurance. It's going to pass to whoever the beneficiary designation form is that's on file with the insurance company. And it's important that it gets filed with the insurance company. I've seen them where someone filled it out, left it on their desk, forgot to mail it in. Sometimes the life insurance company will accept that after death, sometimes not. So if someone wants to really make sure it is going to get to where they want it to get to, they need to not only fill out the form, but make sure that it's sent to the life insurance company. And the way they'll know that is typically they'll get a letter confirming, hey, we've received your change of beneficiary and here's the new beneficiary. Sometimes things get lost in the mail. So if you're working with a beneficiary and they want to leave any type of asset via beneficiary designation, make sure that they get confirmation back from the administrator of the retirement account, the life insurance company, that yes, they received that form and they have updated the records on their file. Because if they don't have it on their file, it's not going to where that last form was. Now with life insurance, we don't have the income tax considerations because life insurance is typically not subject to income tax upon death. Can be subject to estate tax, but that's kind of a separate issue. And it doesn't say here on this slide, but annuities kind of fall into that same category. They're typically held by life insurance companies as well. And like we said earlier, annuities are kind of a hybrid. They're part taxable, part non-taxable. So really some of the same income tax issues apply. Those are great assets to leave to a charity as well, so that the estate does not bear that income tax cost. And so then to the other account slide, even though it's not as common, really any account, whether it's a bank account, checking account, savings account, certificate of deposit, stocks and bonds account, almost any account like that can have a beneficiary designation on it. They just typically don't as often because the people that set up those accounts don't give them a form to sign like they do with life insurance and with retirement accounts and annuities. They're typically called payable on death or transfer on death. So again, the same advantages would apply there, that the charity might be able to get it sooner if they can find out about it, if they know about it. And anything like that would not be subject to the claims of the creditors of the decedent's estate, the debts of the decedent's estate. So if there's not a payable on death or transfer on death designation for other assets like this, then those will always pass to the decedent's estate because they are owned by the deceased person, assuming they're not titled jointly with right of survivorship. But again, that's a consideration. If you've got a donor that lets you know that, hey, I've got, or if you get a feeling that there are some debts out there that might exceed assets, this is a way to make sure you get your bequest without it going through probate, being subject to the claims and subject to the waiting period. And then next, we're going to talk about kind of the procedural issues that a charity faces. Next slide there, which, and every custodian administrator is going to have different requirements. The charity or any beneficiary really is going to have to complete the custodian's forms. Everybody has their own form. All the forms are different. Some custodians are more strict than others. Some are going to make the charity provide proof of authority for the person claiming it. Some just want the letterhead of the charity. Others may actually require a board of resolution authorizing that person to complete the claim form before they'll turn over the funds to the charity. A lot of times they will want proof of the charity's tax exempt status, such as the IRS determination letter. So you should be prepared on the front end really to have all of those things ready, because no two claim forms are the same, and it's very common to have different requirements for each. But those are just kind of some of the common issues there. And I think after this page, I think we're going to go back to Kathy, and I may ask Kathy, if you're listening, to jump in at the end of this slide because you have some more experience with that issue at the bottom. But so IRA administrators can have additional issues as well. There have been surveys that showed that almost half, 43%, of the organizations stated that they've had at least some difficulty in collecting beneficiary proceeds from IRA administrators. And part of that is because those administrators claim, a lot of them claim, well, we don't even have a duty to notify the charity. after the death of the holder, which, you know, kind of boggles my mind. It seems like if they know the person is deceased and there is a beneficiary on file, seems like they would have a duty, but some take the position that they don't. And some may also require an intermediate step before the money passes from the IRA to the charity. And this is sometimes just a technical issue in their software that they have. They may require the charity to open up an account at that brokerage firm called an inherited IRA account. And that is simply, they don't have any other way to run it through their system and get it to the charity without doing that. So if that happens, don't be surprised. They may request social security numbers, driver's license of one of the officers of the charity for that new account, just so they have, with the Patriot Act and different laws, to have authority to actually open that inherited IRA account. And then Kathy, this is where I was going to ask you if you've got your technical difficulties to kind of chime in. But so, you know, the CGP has been working to streamline this process, and we've got a link there that can give information about the successes and failures with different administrators to kind of let you know, okay, if we're having to go to this particular custodian or administrator, we know we're going to have these issues. And I believe there's a way to, you know, add your own experiences to that to help other charities. So Kathy, if you're online, do you want to speak to that?
Sure, this will be a good test to see if I'm actually working. Does everything sound right? Okay.
That sounds much better. Apparently
Okay.
the reboot worked.
Well, and I think this is just another plug for joining our local organization and also pairing that membership with the National Association of Charitable Gift Planners, because they do work on issues like this. So the link that's there is to the RIFT project, and they really are looking at how can we make it easier for nonprofits to get IRA distributions. That's obviously a great asset for a donor to donate to a charity. It's something as plan giving officers we should be talking to all our donors about, because the charity's not going to pay income tax when they receive that gift, but we are having some difficulty. So if you go to this link, you can say, hey, we've gotten a gift from Raymond James. I wonder what Raymond James requires. And then if you've had either a good or bad experience receiving a gift, like we had a great experience with Raymond James. We had one form, filled it out, got the gift almost immediately. And so I was able to add that to that resource center so that other gift planners, when they get a gift from that charity, know what to look for in their form letters. So that's just a great resource that we have. So if we're working, if we don't have any questions, we could go back and see if we could handle the difficult assets part, Sarah. So I'll start, I think, where I left off, which was on the gifts of real estate. And so what we were going to cover here was really just looking at gifts of real estate can be a great gift, but not if the donor wants to offer you a gift of a piece of property that doesn't have access, or a piece of property that maybe was used as a gas station or a dumping station. And so just for your group, for your organization, just to make sure that you've got policies in place, and we're going to talk about gift acceptance policies in just a minute, so you know what kind of real estate you want to accept, and then also to know that you're going to be responsible for the maintenance and upkeep until you sell that property. So if it's a piece of property that is a very unique piece of property, that could be a longer holding time, so something you want to look for. Like at Le Bonheur, we will accept gifts of real estate, but our real estate department has to vet those. And I know Dan mentioned that U of M doesn't accept real estate, but they work through the Community Foundation to accept gifts of real estate from their donors. It's just U of M doesn't take title. The next difficult asset would be closely held business interest. That again can be a great asset and a great gift. A lot of our donors have a lot of their net worth in their business. If their business is FedEx, that's great, because that's really easy for them to gift you that stock. If their business is a very small company, that's going to be more difficult. So you want to make sure that you really look at those gifts. Is there a potential sale, or are they going to give you this gift and then you're not going to be able to liquidate it? And you may also have some tax issues for your company or for your nonprofit for any money that gift will throw off before you're able to sell it. Personal property, which Carlisle talked about a little bit, we will accept cars at Le Bonheur, but we use a separate car vendor to do that, where they deal with picking up the car, selling it. You also want to look at personal property. If I'm Literacy Mid-South and somebody wants to give me a bunch of books, that may be a great gift that I can use. But is it a gift of personal property that you're going to be able to use as a part of your nonprofit? Or is it something that doesn't help with your mission? Cryptocurrency and Bitcoin, I have not received a gift of this, but I understand from other people that it can be a very volatile gift. So it may be worth a whole lot the day you get it, and then it may not be worth anything the next day. So you want to make sure that if you're going to accept this type of gift, that you've got your wallet set up and that you're ready to dispose of it and can dispose of it very quickly. The final thing is really just the new donor. Somebody who calls you and they want to give you a gift and you've never heard of them before, they have no connection to your organization, don't seem to know much about your organization. You may wonder, do they have donative intent, or do they really just have something they want to get rid of? Last year, one of the major gift officers came in my office so excited. A guy had called out of the blue and he had 2 pieces of property he wanted to donate to us. And as we did more research, one was completely in a floodplain, so it was not buildable at all. And the other one had been used as a dump site. And so once we talked to our real estate department and looked at the assets, we realized that it just wasn't a good asset for our organization. And so, most of our donors love us. They want to see us succeed. That's why they want to make gifts to us. But be careful of the donor that you don't have any experience with, who may have an asset that you don't want to take. And then if we go to the next slide, I think that's why it's really important to have gift acceptance policies, so that you know what type of gift your nonprofit will accept and what the terms for that will be. If you don't have a gift acceptance policy, or if you don't know where it is, now is a great time to find it. Or to create it. And I've got some questions on here, and we'll send these slides out later about things your gift acceptance policy should address. What will you accept? Will you accept Bitcoin? Will you not accept Bitcoin? Under what circumstances will the gift be accepted? Maybe your organization says we'll accept real property, but only if it's worth a certain amount, because you want to know that the time and expense that's going to be a part of that is going to be worth it to your organization. How will gifts be recognized and tracked? Dan talked a little bit about that earlier. Our Le Bonheur has a very specific policy about what size sign you get for what size gift. And so things like this really make it helpful, so that your major gift officers, your board members that are out talking to people about gifts, they sort of know what the parameters are. Again, how will major gifts like real estate, life insurance, and stock be handled? And so that will help your organization know before there's a donor sitting in front of you that says, hey, I've made a lot of money in Bitcoin, I'd really like to donate that to you. You know whether that's a gift you can accept, because the worst thing you want to do is tell the donor that sounds great, and then 3 weeks pass and you still don't know if you can accept it, or you don't know how to accept it, and then the donor can get frustrated. And just know that there are groups to help you. Dan mentioned the local donor advised fund sponsors. I know, for example, my church, if we try and sell real property, there's all this denominational approval we have to get. And so somebody wanted to donate property to our church, and instead they donated it to a local donor advised fund. They sold the property and the proceeds were donated to the church. I think, Dan, you said you had a similar arrangement with the Community Foundation, we are U of M. So just know there are groups out there that can help you. And then there's also a guy named Brian Klontz who has a group called Charitable Solutions, and he also can help with unique assets. And so there are groups out there that really are there to help nonprofits be able to take assets that may be difficult for that nonprofit to take. You've got a donor that's got a set of antique guns that you don't really want to take the guns, you don't really know what to do with the guns. But somebody like Brian's group or a community foundation, they may be able to take an asset that you can't, liquidate that asset, and then turn the proceeds over to your organization.
Yes,
Dan,
the
if you want to
Jewish
add,
Foundation also accepts.
oh, good.
unique items. We've gotten Tiffany glass that was donated, coin collections, like was mentioned in the slideshow. So similar to the Community Foundation and other organizations.
And I think it's important because this is such a personal thing for donors. Donors have something that means a lot to them. They've got their Tiffany glass, you know, and they want to see your organization succeed. They want to help the organization. And so there are different ways to do that. It doesn't always have to be a direct gift to your charity. Dan, did you want to add anything on that?
I would just add that gift acceptance policies do provide the organization a lot of protection. Somebody walked in and tried to give you something that you can always say, I've got to take that back to my committee for approval. And that gives you time to do a little research, and then you can go back and tell them that your committee is the one that's declining the gift. It's not a personal just coming from you.
There's a question from, or Frank wanted to say something. Kathy, if you want to.
So I think Frank is talking about that the major problem is IRH brokerage firms are making the nonprofit open the brokerage account. That's, I think, what Mike mentioned, the inherited IRA. And we didn't get into this much detail, but Frank's exactly right. You know, the charity actually can't hold the IRA. And so that's really what the national group is trying to get legislation passed to say, you know, the charity is not the proper person to open this inherited IRA account, so don't make them go through those steps. And they're actually looking right now for a charity who will be sort of that test case to say, here's the problem that we're having. One issue with that is, I think a lot of organizations want to receive their gift, but we were talking about this on Monday, preparing for this. As an organization, you may not know how much that gift is until you fill out all the paperwork. So I was listening to a national seminar, and they said a group had gone through all this paperwork and they got a check for like 57 cents. So it's difficult to know how much the gift is that you're working on until you actually receive it. So hopefully the national group will get some traction on that. Thanks, Frank.
If there's nothing else, this slide right here has the resources that have been mentioned throughout the presentation today. Joining the Planned Giving Council of the Mid-South. Usually we do host these in person with a lunch. Today, due to COVID, we're all online. If you have any questions, feel free to email any one of us. We will be sending out the slides afterwards and posting the recording on the website for the Planned Giving Council of the Mid-South. Joey, did you have anything else to add?
No, I don't think so. Thanks everyone for coming, for joining us for both of these programs. Again, would love to have, I know there's 9 or 10 folks that registered, and we're here today and 2 weeks ago for our programs that are not members. I would love to have you join. Feel free to reach out to me or any of us on the board if you have questions about joining or the benefits associated with joining the Planned Giving Council of the Mid-South. As Sarah said, we hope to get back to some normalcy in 2021 and have these programs in person. But super grateful for your participation today and 2 weeks ago, and we'll be reaching out to survey you on future programs and opportunities to improve these sessions. Thanks again.
Thank you.
Thank y'all.